SJC-13454, Commonwealth v. Warren W. Dunn.
And Attorney DeMeo, whenever you're ready.
Thank you. May it please the court. Christopher DeMeo for Warren Dunn, and with me today is Sabrina Bonanno, who was counsel for Mr. Dunn in the Superior Court. Time permitting, I'd like to talk about three things today. The first is whether the search warrant application here established probable cause that there would be child pornography in Mr. Dunn's house on his devices. I'm going to briefly suggest that this court adopt a rule like they have in the First Circuit that magistrates look at allegedly lewd images.
That's not the rule.
Well, it's a best practice rule.
Okay, that's not the rule.
Okay. And third, if I have time, I'll talk about the Franks issue. So before getting into whether there's probable cause, I think it's best to clear up one point. And I think this was assumed by Judge Buckley and the trooper, which is that unless the two photos are themselves lewd, there would not be probable cause to go and search somebody's house for child pornography. And I think that there'd be First Amendment issues if protected materials that were not lewd could be used as a predicate to go and search someone. I only mention that because parts of the red brief seem to suggest, well, there were nude minors and Mr. Dunn was a sexual offender, so that's good enough for probable cause. I don't think that's the case. And I have a cite actually from this court's 2014 Rollins case, which says, this is page 80 of Rollins, it says, "We fail to see how the possession of legal photographs is probative of the defendant's knowing or intentional possession of illegal photographs." So it seems our position is the question for the magistrate and then for Judge Buckley was there probable, were these two photographs lewd such that there would be probable cause?
To what extent does the Microsoft flagging of the images plus the NCM's, the NAMEC hashtag values associated with pornographic images impact probable cause? I read this court's Rex case to say that whether an image is lewd or not lewd depends on the four corners of the image itself. And I have it, it's in a footnote I could read, but I think it's footnote 13 of the Rex case. So to me, I mean, that's why I think this best practice rule makes a lot of sense, because you actually see what the image is. But barring that, it's a best practice if the description is inadequate. But
yes, sure.
Okay, so
let's to get to Microsoft, you know, I guess my answer is it's lewd or it's not lewd, and it's not really a vote until it gets up to an appellate court. So it was for the magistrate to say, and the magistrate had to.
But isn't that a factor the magistrate can take into consideration along with the description?
If the magistrate knew something about this Microsoft process, perhaps, but we don't. I have no idea what. I assume Microsoft has some algorithms or artificial intelligence that screens millions of images and reports a certain subset.
The hash values are flagged known pornographic images, correct?
That Microsoft assigned them some, yeah,
no,
B2.
The National Center has cataloged these images and assigned hash values to known pornographic images, correct?
Well, my understanding is the National Center, I thought, was just a clearinghouse and forwarded it from the service provider to whatever the local authority is. So I'm not prepared to agree with that as I stand here, although I'm not disagreeing with it either. But I guess to know if the question is broadly, other people or other companies thought these were suspicious photos as well, I don't really think that can play into the probable cause.
That doesn't add anything to the probable cause?
Unless we know why they thought.
Answer the question. Does that add anything to the probable cause determination?
Does what add anything?
The fact that there are known images of child pornography as reflected in the hash values.
I don't understand what it means to say they're known to the National Center.
Mark, they're flagged as known images of child pornography, and I'm trying to ask you whether or not it's appropriate for
an issuing magistrate to take that into consideration along with the description.
I think that should be based on the four corners of the image itself. But if you couldn't look at the image, I agree that in theory, if you had some other reliable source, and I don't actually know anything about how this came to be given that label B2, that could perhaps be something you take into account. But I read the Rex case to say you look at the image itself and it's lewd or it isn't lewd. And the same goes for Mr. Dunn.
Or you pay attention to the description. The Rex case doesn't say you look at the image. The question is whether the description is adequate to establish probable cause.
Right. Well, the Rex case wasn't really this kind of issue about the sufficiency of the warrant. It was actually looking at the images themselves. But yes, yeah.
That's
right.
the issue before the court.
That's the issue
whether the description was adequate to establish
Correct,
probable
correct.
cause.
Is a magistrate better equipped to figure out whether an image is lewd than the National Center?
Well, yeah, I mean, I don't know. I don't see how the First Amendment requires that there's a judicial officer who's making the initial call. So I don't see how that can be delegated to any third parties. Or there's
Well, it's not delegated, but I guess I'm thinking about the magistrates. So I understand you're saying it's best practice to look at the photograph, but you'll agree it's not required.
It's not.
Like it to be required.
Yes,
but it's
sure.
not.
As the law stands, it's not required. I agree.
So you want us to change the law?
Well, I mean, if what's required is that the description is sufficient, I guess, at this point, and it doesn't get any better than having the image. So that's why we think
Is that why we say a picture is worth 1,000 words?
correct. That's correct. So that's why we think the brunette rule makes sense. But
But if the description satisfies the dose factors, it's fine.
that's what courts have held. And I mean, even in the first.
The dosed factors, why wouldn't that also, in addition to the description, in addition to Microsoft, in addition to the focal point issue, why couldn't the dose factors also take into account, if we look at our previous case law, that he's already been convicted of child pornography?
Because I believe in the Rex case, it says specifically, I guess I keep getting back to it's an objective, or it's not objective, but it doesn't become, it's either lewd or it's not lewd, and it doesn't become.
Yeah, but what you're saying, and I think this is the point I just got to ask questions, I mean, what you're saying is, yeah, if you attach it to the affidavit, the magistrate can take a look at it. But if you're not required to attach to the affidavit, and every time somebody looks at this, the child is re-victimized. So if you don't attach it to the affidavit, whatever the best practice might be in the First Circuit and other places, right, why wouldn't all these other factors be considered in trying to calibrate whether it reaches the level of probable cause?
Well, if you're not going to actually attach it, it seems to me you need to have a very. The magistrate is the one who has to make the call. He needs to have sufficient facts to be the neutral judge, and not the police. So you see in the record, you see both sides go on describing these photos for a page or two each, and they have somewhat different descriptions. But that's a detailed description, and I guess if you're not going to require the actual photo, you need saying the photo of the focus of the photo is the genitals. I agree it's a little bit better than brunette, where they just said it's lewd, because that's a legal word, but it's not a whole lot better because
when you say it's best practice in brunette, as I read it, says because you use statutory language, it was deficient. And then the case goes on to say because the affiant used the statutory language, the magistrate should have viewed the images. That's
not the law in the First Circuit. We also cite the Sheehan case where they did not use this. It's from just a few months ago, and they used a description, albeit a short one, and the court applied brunette in Sheehan and ruled that there was no probable cause.
There's no focal point in the image in Sheehan, though.
That's true. They didn't use the word focal. The problem with focal point.
Well, they used the word. There was no. You talk about the four corners. There was no focal point in the Sheehan case.
I think the Sheehan case said it consists of photos of pubescent genitals or something like that. And the U.S. attorney argued, well, if it consists of them, then that's what it is. And they tried to argue that means it is the focal point. I guess
Isn't that your best argument, is the focal point is subjective unless you look at the picture, right? I mean, you're trying to expand that we have to look at every single picture and we can't take into account other factors. But your best argument is the focal point, whether it's on the sexual organs, can't really be discerned unless you look at the picture, right?
In my opinion, it's just subjective in that different things can be, reasonable people could disagree about the focal point. So to get back to
there's nothing else also in the affidavit that suggests that this is lewd besides the focus on the.
No, it says it's nude males, age 13 to 15, and we know it's well settled that nudity alone is not lewd. So the whole thing stands or falls, it seems to me, on the focus issue, unless you give some value to what Microsoft or somebody or other said.
Even if you do give some value, which our cases do that, you still have to decide whether it's a focal point, right?
I think you do, and you have to decide, I should say, that it's lewd, and one of those factors is focal point, and since that was the only one that was proffered here by the trooper, the magistrate really just took him at his word, it seems.
And we don't really have much in the way of detail of why the officer thought it was focused on the sexual organs, right? We just don't have much to work from in the affidavit. It doesn't say this is a close-up or whatever, right?
It doesn't say, yeah, there's many, it could be a close-up, it could be, just the way the picture, you see cases where legs are spread. There's many different ways it could be the focus, and because we just don't know. It's not legally conclusory like in Brunette where they said it's lascivious, but it's conclusory in kind of a factual way where the magistrate is really not in a position here to make the independent call that he's supposed to make.
Conclusory with regard to the first dose factor, right, which is what is the focal point?
Correct.
But the other factors are something that the magistrate couldn't have weighed.
Well, he could have. One of the dose factors is, are they naked, and no one's disputing that, I think. But yeah, it doesn't say anything about the poses or whether it's sexually suggestive. I'll just represent to the court. They're outside. It's pictures of two boys standing out in the out of doors. It doesn't strike me as designed to elicit a sexual response. Really, you can't really decide these things without, it all turns on the details without looking at them. So I appreciate that you shouldn't lightly go spreading these pictures about. But on the other hand, people have there's two First Amendment rights at stake here. It's not just or two constitutional rights, not just the First Amendment, there's the Fourth, because they're going into somebody's house. So if you go into somebody's house on the alleged probable cause created by something that's not in fact lewd, you have a Fourth Amendment issue and a First Amendment issue. So
Can I pin you down on one more factual issue?
Yeah.
The Microsoft targeting, I may have misread this. Was it suggesting that these children have been identified as having previously been in child porn pictures? Is that what the label there? Is that what that B2 label means or no?
I thought the B2 label just meant that somehow through some process Microsoft, they say what A1 means in A2 and B2.
And what does B2 mean exactly?
B2 means it kind of parrots it's lewd and lascivious display of the.
But it's not that these children had been previously identified.
That's not what I understood it as, although I know Justice Gaziano was talking about the hashtag, and that's why I said I'm not prepared to. It seems to me this is just a routine thing where service providers report certain through their screening, but which we don't know about.
But is it we don't know about it because you don't know about it standing there, or is it just not in the record?
I don't think it's in the record.
Okay.
Yeah.
Has any court gone further than the Ninth Circuit in saying it's preferable?
No, not that I'm aware of. I mean, the First Circuit said it's preferable to. Again, in the Sheehan case from just a few months ago, they actually reversed a conviction because of this. So,
But Sheehan does not have a personal viewing requirement.
No, I agree. I'm not arguing this court should do anything other than make it a best practice. I mean, I'm not saying,
I thought that's what your brief said, the other opposite.
yeah.
You said that we should make it a requirement.
Well, you should make it you should tell people that if the police and prosecutors know,
Don't run away from your brief. You said we should make it a requirement.
you should make it a requirement. But I mean, if there's a lot of other, well, I can't think of an exception, but if you don't want it to be an ironclad rule, it should certainly be a best practice, and the Commonwealth should know that they, at their peril.
Well, that's the issue, is it's at their peril. So if they use statutory language, or if we think focal point is not enough, then it is at their peril if they don't attach it. That's absolutely right.
Yeah. All right, I didn't have time to get into the Franks, but I'll leave it.
Rest on your brief?
Yeah.
Okay.
Thank you.
Thank you. Okay, Attorney Marvel.
Good morning. If it may please the court, Elizabeth Mello Marvel for the Commonwealth. Just to clarify the Commonwealth's position in regards to the corroborating factors and in looking at the Microsoft and National Center for Missing and Exploited Children, I think there's a little bit of confusion. I would just direct the court to page 7 of the trooper's affidavit, which is page 45 of the defendant's record appendix. That's where the discussion begins about how Microsoft reports that there are 2 uploaded images. They flag them that these may be of concern. And then the National Center for Missing and Exploited Children, they maintain a cyber tip line where providers such as Microsoft can forward those. And it's the National Center for Missing and Exploited Children that have the hashtag values, and those are described at the top of page 8, where they're talking about whether or not it's a child previously identified, whether or not these are photos that they've seen before. So I just wanted to direct the court's attention, because I know that it gets a little bit confusing in the affidavit. But again, this goes to the trooper describing
So what does that mean then? So what do we take from what's in the record? Is this child, were these pictures of kids that had previously been exploited or not?
Well, these particular photos were given a hashtag value, and I can find that. I did mention it in my brief. It doesn't necessarily mean that they are, if I remember correctly, I don't believe that they were necessarily, the children were identified or known, but that there were photos that had previously been known to the National Center for Missing and Exploited Children. But that does not mean that they're saying they're actually child pornography under the Commonwealth statute. They're just saying these are photos that have come across, they've been flagged, they may have been flagged in Utah, they may have, it could have been from anywhere.
And do we know the algorithm that was used to flag them?
I do not. I do not know enough about.
We only know that these photos have at some point been flagged. We don't know why, but they're now part of a database at the National Center.
Correct. That's my understanding. And again, this is by way of the trooper describing how he became aware, the mechanism by which he became aware of this.
So we can just say that based on the hashtag, it's suspected child pornography.
Exactly. They're not saying that it is. They're just saying this is suspected. Then he goes on to talk about all of his training and experience, talks about what he knows of the defendant, and not that that means that it's child pornography, but again, it's another factor that can be considered, and then talks about viewing the photos himself and giving a description.
Do other courts take into consideration the experience of the officer identifying the photos as lewd?
Well, he didn't identify them as lewd. Just to clarify, he gave a verbal description of it.
But you're asking us to rely on his 12 years experience, which is substantially different than Brunette, who only had, I think, a year and a half. But I'm wondering, are other courts relying on, in any way, on an officer's experience to conclude there's probable cause for a lewd image?
I think there's reliance on an officer's training and experience in an affidavit in a variety of cases.
Right, but specifically where the First Amendment is at issue.
Right.
Yeah.
Well, if you look at Commonwealth v. Gaustucci, Gaustucci, 486 Mass 22, that's a 2020 case, that had to do with the staleness of a search warrant in regards to child pornography, so a little bit different issue, but in that in that particular case, they did talk about the corroborating factors, the defendant's interest. So there was description there about the officer, I can't remember if it's an officer or a trooper, the experience in describing people who have, quote unquote, collected these types of images in the past. So there's a whole discussion about the officer's knowledge in that particular area. So it'd be my position
Sorry, just to be clear, the officer's knowledge as to a particular photo being lewd or
again, I apologize.
no violation, or was it just the officer's knowledge as to the type of person that?
No,
It was a hoarding issue in Gastucci as to whether or not he'd still have the images because he went in the
Correct.
chat room and he was hoarding the images. In the officer's experience, saying that people that possess child pornography are likely to cache them and hold them for particular amounts of time.
correct, I apologize.
It was a different issue.
Correct. I apologize if I misunderstood the question. I thought the question had to do with what kind of value are we giving, or what kind of consideration should a magistrate be giving to the officer's experience in this particular area?
Yeah, in connection with identifying, or determining whether there's probable cause that the image is lewd.
Correct.
Yes.
So that these are,
The Gastucci case doesn't sound like it is on point.
Well-
Are you aware of any cases that defer to the officer's experience in connection with making this First Amendment determination?
that would have been my best case for that particular. I think in other areas of law, it is pretty clear that that is what is done. And I think as far as the First Amendment issue, in other types of cases, when you're looking at, say, for example, a threats case and an application for a complaint, a criminal complaint, the officer is describing the threat and what happened. He isn't required to bring in visual documentation of the threat itself. So
in those kind of cases, you're aware of affidavit where the officer says he threatened without describing the threat, like he got face to face with him and whatever.
I'm saying the opposite, I guess. I'm not aware of a rule that where an officer is required
But it's
to
completely
attach that.
different. Those other cases, the nature of the crime is not the image. It's analogous to a best evidence rule issue in a lot of ways. And what you have here is the crime is the possession of the image. So the description really matters a lot more than the training and experience. And even if the training and experience somehow on what's lewd and what isn't lewd might count for something, the magistrate has no way to evaluate that if the magistrate doesn't have a description that's not just bare bones.
Well, the question here is whether or not, for the purposes of probable cause, which is a very low standard, as we are all aware, whether or not an officer's affidavit is enough. And that's really what we're talking about. Is it enough for an officer to describe what he sees? And the system is set up where...
Could I just follow up on both your point and Justice Lowy's point? So we are talking about the adequacy of the description in the affidavit's averments. Is there any meaningful difference between what was done here and what was done in Brunette? And I say that because Brunette's problem was the affiant just used just parroted conclusory language from the statute. And doesn't the affiant here just do the same thing under the dose factors? He just takes the first dose factor and says, this is the focal point. There's really no meat to that description. There's no definition to that. There's no description of, here's the photograph, there's an enlargement of the picture, it zooms in on this particular part of the picture. It just does the same thing that the affiant did in Brunette. What's the difference?
The difference is, in Brunette, you had, I believe it was an agent, the law enforcement personnel there was not experienced, that was clear, and simply parroted the language. The trooper here did not parrot the language. He did not say, this photo is lewd. He said...
Well, the first dose factor says whether the focal point of the visual depiction is on the child's genitals or pubic area. And Trooper Donovan says, quote, that the photo depicts a pubescent male standing completely naked with the focus of the image on the young boy's penis. Now, we can argue all day long about whether or not it's verbatim what it says in the first dose factor. It's not. But as a practical matter, that's all he does is repeat what's in the first dose factor. So again, I go back to what's the functional difference between what's done here and what was done in Brunette?
Because he's describing what he saw, and the officer in Brunette did not do that. He got to the conclusion and didn't look at it and describe it. The fact that his description happens to fit and follow one of the DOS factors, that's simply something to be taken into account. But he looked at the photo, he described it, he gave the other information that he had. If the magistrate felt that, hey, I need more detail, go back and add more description, or I don't think it's enough, I'm denying this.
How do you do that without looking at the picture? I mean, how do you know that it's focused that way? It's just so subjective. I mean, you cite the Sullivan case, which I'm familiar with. I remember sitting there, we had 25 different appellate judges looking at this picture, trying to figure out where the focus was. How do we do that when we don't have this as a close cropped image? We don't have, this is, I don't know the terminology where, where they're close to the crotch or close to the breast. We don't have any kind of precise detail here. We just have a picture that there's a naked child with the focus, according to the cop, on the sexual organs, but no description of why he comes to that conclusion.
The question is, can a magistrate reasonably rely on an affidavit from, and the trooper has spelled out, I've got X number of years experience.
Just because he's the 20-year cop doesn't, that seems to be a make-weight factor. I mean, I just don't, every one of the police officer affidavits describes their experience. If an officer's been doing this for 1 year versus 8 years, in terms of looking at pictures, that makes a big difference.
Again, you can't parse out one individual. You're looking at all of the pieces that together make the probable cause. No different than if you look, again, it's a completely different situation, but similar to looking at, you look at a drug case like Fontaine, where you're talking about additional facts known by the officer. In that case...
Yeah, I think you're right. You do look at the totality, but each individual piece seems to be lacking in something. First, we don't know in the record how these hashtags get assigned. And so we have no idea what the algorithm is. Second, as Justice Kafker was saying, 12 years versus a year and a half, identifying lewd images and being exposed to them. I'm not sure that qualifies this officer any more than a magistrate. And then we have a description that is consistent with art in some ways, and so protected by the First Amendment. So in the absence of a fuller description, or the attached image, I'm not sure how the magistrate makes the assessment without violating the First Amendment. Can you address that?
Yes,
I agree with you. It's the totality of everything, but each piece seems to be substantially lacking.
I would respectfully disagree with that. We're talking about hashtag values being assigned by the National Center, which is that is the center that's the focus. This is what they do, is exploitation of children.
I don't know how they do that, or at least the record doesn't tell us.
Okay. So the fact that, and then you have the officer whose primary job and training and experience is all focused on cybercrime and children. That is what they know. I would argue that is something to be considered, as opposed to an officer that has no experience and no training, or a magistrate that has no experience and no training, simply looking at the four corners of a photo.
Would we be moving a goal line? We told police officers don't use statutory language. They don't use statute. We said use the dose factors. This officer used the dose factors, and then we said, well, don't just use the dose factors. Those are conclusory. And here we're not dealing with beyond a reasonable doubt. We're dealing with probable cause.
Correct. And that would be the question, is then what should, if the officer looks at the image and says this is the age, this is a male, they're standing here, they're nude, the focus is, I guess the direction would be how much specific do they have to be? How much language do they have to put in order to satisfy the PC standard? Again, we're not talking about.
That argument seems to really support the defendant's argument here that the best practices would be to just attach the photo and not try to use the 1,000 words to describe the photo. I'm not suggesting that that is the standard, but that might be the best practice.
Again, the Commonwealth's position would be that it would not be the best practice. What that would result in is every single affidavit in one of these cases across the entire Commonwealth would have all of these images attached. Every time an officer was applying for a search warrant, they then would need to be impounded. Again, and it's not necessarily
So the
something.
standard practice is not to look at the photos? This is not, is that right? The standard practice is not to attach photos in these cases?
I don't know that I can speak for every single
It
detective.
just seems odd.
I don't believe that they would want to distribute and put it out there.
We're not the public. It's
I
a judicial
understand.
officer, right? It's a judge. They're not gonna, we're not putting this on the internet. Can I ask one last question? You said that the fact that he'd been previously convicted, what's the best case about how you weigh that factor? I'm just trying to understand that.
Defendants past, if you look at the Fontaine case, it's a drug case, but it does talk about the defendant's history. That's the 84 Mass App Court, it's a
Are there
2014.
good cases for us to look at where the fact that someone's been previously convicted of child pornography?
I had mentioned Gastucci, again, for a little bit different reason, but again, considering someone's history in
Well,
assessing.
if someone's convicted of distribution of drugs, and then when there's a drug affidavit, we can consider the fact that they prior conviction of drugs, right?
Correct.